Today, we're tackling something that quietly underpins pretty much every commercial interaction you have, the Uniform Commercial Code, or UCC.
Mm,
It's not exactly headline news, maybe, but understanding its hidden gears it can really change how you see the world of commerce.
absolutely. Yeah, it's fundamental. And to get a handle on this, we've pulled together a really interesting set of sources.
Okay.
We've got the official word from the Uniform Law Commission itself, naturally. Then there's a clear breakdown from the Legal Information Institute, which is super helpful.
Right.
And then this other source, the Avari Solutions educational album, UCC Law for the Living.
Oh, yeah. That one sounds intriguing.
It really is.
Mm.
It offers a surprisingly practical and honestly almost philosophical take on commercial law in our everyday lives. It's a different angle.
Exactly. Our goal here isn't some dry legal lecture. We want to unpack the core of what the UCC is, why it's so fundamental, and maybe point out some of the unexpected ways it shapes how we participate uh, in the commercial landscape, sometimes without us even realizing it.
hmm
Think of it as getting a key, maybe, understanding the invisible infrastructure of how we buy, sell, contract, all that stuff.
Yeah, the rules of the game, so to speak.
Exactly. So what is this UCC we keep talking about? Let's start there.
Okay, so in simple terms, the UCC is a comprehensive set of laws that governs, well, most commercial transactions throughout the United States.
Most.
Yeah. Now, this isn't some federal law cooked up in Washington, D.C. That's a common misconception.
Ah.
Instead, it's actually state law. Each state has adopted these uniform rules.
Uniform roles across all states. That sounds like a huge logistical necessity. Why go to all that effort? Why does that uniformity matter so much?
Oh, it's absolutely crucial, especially when you think about businesses operating across state lines.
Right. Yeah.
I mean, just imagine the regulatory nightmare if every single state had completely different rules for, say, sales agreements or how you handle checks.
It'd be chaos.
Total chaos. So the UCC provides this baseline of predictability. The businesses can be much more confident that their contracts, their transactions, they'll be interpreted and enforced in a pretty similar way, regardless of where their partners are located.
Okay, so this legal certainty isn't just like a nice to have. It actually fuels the economy, doesn't it?
Precisely, yeah. When businesses can rely on a consistent legal framework, they're much more willing to take risks, to invest, to grow.
Makes sense.
This predictability is really a cornerstone of a healthy, dynamic American economy. It's why calling the UCC the backbone of American commerce really isn't an overstatement. It truly is.
The backbone of American commerce. Okay, I like that. That gives us the what and the why. Now, let's dig into the how. This didn't just spring into existence fully formed, did it? What's the backstory here?
No, definitely not. The story really begins way back in 1892. That's when the Uniform Law Commission, or ULC, was established.
1892.
Yeah, and their core mission, right from the start, was to create precisely this kind of standardized legislation for commercial activities.
And they got to work pretty quickly then. I think I saw the Uniform Negotiable Instruments Law in 1896. That seems like a pretty foundational piece early on.
Absolutely. That was a very early and very successful example of their work. It really laid the groundwork for future uniform laws.
Great.
Then in the early 20th century, they started tackling other areas, things like sales of goods, warehouse receipts, bills of lading, all essential components of a functioning commercial system.
Right, the nuts and bolts. But these were still individual laws sort of addressing specific areas. When did the idea of consolidating everything to one big code emerge?
Yeah, good question. The ULC recognized the need for a more unified approach. They began the really ambitious project of drafting a comprehensive code in 1940.
1940.
Then, in 1942, they joined forces with the American Law Institute, or ALI.
Ah, the ALI.
Yeah, this partnership brought together just a wealth of legal expertise, a real meeting of minds.
A power team, basically. So after all that collaboration, when did this unified UCC finally, come into being?
The complete Uniform Commercial Code was presented to the states for adoption in 1951.
51, okay.
Yeah, it was the culmination of over a decade of really intensive drafting, refinement, debate.
And the states were quick to see its value, weren't they? Or did it take time?
Well, Pennsylvania was the first to adopt it in 1953.
Okay.
And then within the next 2 decades or so, every single other state in the country had followed suit.
Wow, all of them.
Yep. That near-universal adoption really speaks volumes about the fundamental importance of the UCC for American commerce.
From idea to nationwide adoption in, 50-ish years? That's
Yeah.
That's quite something. But look, the world keeps changing. Technology, business practices. How does the UCC stay relevant? How does it keep up?
That's a great point. And that's where the Permanent Editorial Board for the Uniform Commercial Code comes in, the PB.
Okay.
It was established back in 1961, and it's made up of appointees from both the ULC and the ALI, maintaining that partnership.
So the PEB is like the UCC's ongoing maintenance crew. Is that fair? What do they actually do?
Uh-huh. Yeah, that's a pretty good analogy.
Yeah.
Their job is basically to continuously monitor developments in commercial law,
Okay.
identify areas where the UCC might need updating or maybe just clarification, and then they propose amendments and revisions.
And they issue commentary too, right, to help
Yeah.
interpret it.
Exactly. They issue official commentary, which is really important for helping courts and lawyers interpret the often quite detailed provisions of the code.
So it sounds like a living document then, constantly being refined.
It really is.
And is there like a system in place to fund this ongoing work? It sounds resource intensive.
Yes, there is. The initial funding actually came from a generous grant from the Maurice and Laura Folk Foundation.
Oh,
And that endowment is also supplemented by royalties from the publication of the UCC itself. So it's kind of a self-sustaining mechanism for ensuring the code remains current and effective.
okay, that makes sense. So we've got the foundation, the history, the upkeep. Now let's get into the specifics. The UCC is organized into these articles, right? Can we maybe walk through some of the key ones and what they actually cover?
Absolutely. Let's do that. So Article 1, titled General Provisions, that's really where it all begins.
The starting point.
Yeah. It lays out the fundamental definitions used throughout the UCC, establishes some overarching rules, sort of the groundwork that applies to many of the other articles. It was last updated in 2001, mostly to ensure consistency with changes made elsewhere in the code.
Okay. Then we jump into Article 2, sales. That sounds pretty central to commerce.
Oh, it is. Hugely central. Article 2 governs pretty much any transaction involving the sale of goods.
Goods specifically, not services.
Primarily goods, yes, though we'll touch on mixed transactions later. Article 2 actually evolved from an earlier law, the Uniform Sales Act of 1906. It was a core part of the original UCC back in '51.
Right.
Interestingly, there was an attempt to modernize Article 2 in the early 2000s, but, well, it didn't gain widespread support among the states and was eventually withdrawn.
Huh. So the original still stands.
Pretty much, yeah.
Yeah.
The original 1951 version remains the official text in most states.
Okay. Right after that in the list, we have Article 2A, dealing with leases. How does that differ from a sale under Article 2?
Good question. Article 2A specifically addresses the leasing of personal property. Think equipment leases, car leases, that sort of thing.
Yeah.
It's a distinct type of transaction from a sale where ownership eventually transfers.
Right. You don't own it at the end necessarily.
Exactly. Article 2A was actually added to the UCC later in 1987 and then amended a bit in 1990. And similar to Article 2, a proposed revision in the early 2000s also didn't move forward, so the 8790 version is what's still in effect.
Gotcha. Moving on to Article 3, negotiable instruments. Now, that sounds like it deals with how we actually pay for things.
You got it. Article 3 covers instruments like drafts, which include your everyday checks, and also promissory notes. Basically, written commitments to pay a specific sum of money.
Checks and promises to pay.
Right. And what makes them negotiable is key. They can be transferred to another party, who then also have the legal right to enforce the payment. Think about endorsing a check over to someone else.
Okay. That transferability.
Exactly. Article 3 has deep roots, going back to that Uniform Negotiable Instrument Law of 1896 we mentioned. It was significantly revised in 1990, with some further smaller updates in 2002.
And closely linked, it seems, we have Article 4, bank deposits and collections. That sounds like what happens after you write that check.
Precisely. Article 4 outlines the rules and procedures that banks follow when processing checks, handling deposits, and transferring funds between different banks. The whole check clearing process.
The plumbing of the banking system for checks?
Kind of, yeah. It also underwent a major revision in 1990 and had those related amendments in 2002 to reflect changes in banking practices, like electronic processing.
You mentioned the 2002 amendments to both Articles 3 and 4. What were the big drivers for those updates then? Was it just technology?
Yeah, technology was the primary driver. The main goal was to modernize the legal framework for handling payments, particularly checks and other paper-based instruments, to take into account the increasing use of electronic payment technologies and check truncation.
Right, scanning checks instead of shipping paper everywhere.
Exactly.
Then there's Article 4A, funds transfers. That sounds like it's specifically about electronic payments, maybe wire transfers.
Yes. Article 4A provides a comprehensive legal structure specifically governing the rights and responsibilities associated with funds transfers, especially large-scale electronic transactions between financial institutions. Think wire transfers, ACH payments.
Okay.
It was added to the UCC in 1989, really recognizing the growing importance of electronic commerce even back then.
And even that has seen updates. With the 2012 amendments to Article 4A, what did those address? Seems quite specific.
They were quite specific, yeah. The 2012 amendments clarified how Article 4A applies to what are called remittance transfers.
Remittance transfers.
Yeah, these are often consumer-to-consumer international money transfers. The amendments aim to clarify things when those transfers aren't already regulated under the Federal Electronic Funds Transfer Act, or EFTA. It was about aligning the UCC with existing federal consumer protection laws in that specific area.
Okay, keeping things coordinated. Next up is Article 5, letters of credit. What role do those play in the commercial world? Sounds kind of formal.
They are pretty formal, but they're a really vital tool, particularly in international trade.
Ah, international.
Yeah. Essentially, a letter of credit is a bank's guarantee of payment to a seller, issued on behalf of a buyer. It provides security for the seller. They know they'll get paid if they meet the conditions, and it facilitates smoother international transactions.
So it builds trust between parties who don't know each other well.
Exactly. Article 5 was updated back in 1995 to reflect technological advancements like electronic communication and also just modern practices in trade finance.
Now, Article 6 is bulk sales, but it sounds like it's largely considered outdated now. What happened there?
Yeah, that's right. Article 6 was originally designed to regulate the sale of a business's inventory in bulk, like selling off most or all of their stock outside the ordinary course of business. The main goal was to protect the business's creditors from fraud, where the owner might sell everything off cheaply and disappear with the money.
Okay, seems like a reasonable goal.
It was, but over time, many felt that Article 6 wasn't really serving its purpose effectively and could even hinder legitimate business sales or reorganizations.
Yeah.
It was seen as cumbersome.
So what did they do?
As a result, back in 1989, both the ULC and the ALI actually recommended that states either repeal Article 6 entirely or adopt a significantly revised, streamlined version.
Then what happened?
The vast majority of states just opted for repeal. It's largely off the books now.
Wow, that's a pretty decisive vote of no confidence. Okay, what about Article 7, documents of title?
Right, Article 7. This deals with documents that represent ownership or the right to receive goods, things like warehouse receipts, which you get when you store goods in a warehouse, and bills of lading used when goods are being transported, like on a ship or truck.
So paper that stands for the actual goods.
Exactly. It was revised in 2003 significantly to bring it into the digital age by creating a framework for electronic documents of title. So you can have an electronic bill of lading now, for instance.
Makes sense. Article 8 covers investment securities. That sounds like it's about stocks and bonds and the financial markets.
You got it. Article 8 provides the modern legal framework for how investment securities, stocks, bonds, other financial assets are held and transferred. Critically, it covers how they're held through intermediaries, like brokers and clearing corporations, which is how almost all securities are held today.
The indirect holding system.
Precisely. A major revision in 1994 really updated the rules governing this system, clarifying how ownership and other interests in securities are recorded and changed, and outlining the rights and duties of the various parties involved: the investor, the broker, the clearinghouse. It's fundamental to how our modern financial markets operate smoothly.
Yeah, sounds critical. Then we get to Article 9, secured transactions. That sounds like it's about loans where something is pledged as collateral, right? Like a car loan.
Exactly. That's the classic example. Article 9 is a very comprehensive, very important article that governs transactions where credit is extended, and that credit is secured by personal property, which could be anything from equipment and inventory to accounts receivable or, yes, your car.
So not real estate, but personal property.
Correct. Real estate mortgages are handled under different laws. Article 9 establishes a system for publicly recording these security interests, usually through filing what's called a financing statement.
Ah, public filing. Why is that important?
So that everyone knows who has a claim on what property. It establishes priority between different creditors if the borrower defaults. Article 9 underwent a huge overhaul in 1998. A major revision that was widely adopted, and there have been several subsequent amendments since then to fine-tune it.
You mentioned some specific amendments to Article 9. What were some of the key areas they addressed? Anything stand out?
Well, the 2010 amendments, for instance, aim to provide clear guidelines on how to accurately list the name of an individual debtor on a financing statement.
Seems like a small detail.
It sounds small, But getting the name exactly right is crucial for ensuring that these public records are effective and can be properly searched. A typo could mean a creditor loses their secured position.
Okay. High stakes detail.
Definitely. Then the 2018 amendments focused on refining rules around the assignment of rights, specifically carving out certain ownership interests in entities like partnerships and LLCs from some standard rules that might otherwise prevent them from being used as collateral. A bit technical, but important for business financing.
Okay. And finally, we get to the really new stuff. Article 12 and the 2022 amendments. This sounds like it's grappling with the latest technological advancements, virtual currencies, blockchain.
Absolutely. This is the UCC adapting to the 21st century in a big way. The 2022 amendments, which include the introduction of a whole new Article 12, represent a significant step towards addressing these emerging technologies.
So what do they cover?
They provide updated rules for commercial transactions involving things like virtual currencies, other digital assets based on distributed ledger technology like blockchain, and even touch on the application of AI in commercial contexts.
Oh, okay.
Article 12 specifically introduces rules for a new category called Controllable Electronic Records, or CRs.
Sears.
Yeah, think of certain types of digital assets where you can demonstrate exclusive control, like some cryptocurrencies or potentially certain types of non-fungible tokens, NFTs. The rules establish how you take possession, transfer them, and use them as collateral under Article 9.
Fascinating. Bringing digital assets into the commercial law?
Exactly. These updates also clarify how the UCC applies to transactions that involve a mix of both goods and services, which is increasingly common, along with other general clarifications. It's all about ensuring the UCC remains relevant and adaptable in a really rapidly evolving technological landscape.
This has been a really helpful overview walking through the structure. It's complex, but you can see the logic. Now, I want to pivot, like we mentioned earlier, and discuss that really fascinating source, the Acari Solutions educational album, UCC Law for the Living. This sounds like it offers a completely different lens, maybe a more experiential one.
It does indeed. It's a very different flavor. While the official UCC text and the legal interpretations focus on the precise legal mechanics, the definitions, the procedures, UCC Law for the Living aims to explore the practical, almost philosophical implications of commercial law in our daily lives.
How so?
It looks at how the UCC's underlying principles are actually at play in transactions we engage in constantly, often, as you said before, without a deep understanding of the legal underpinnings. It tries to connect the legal code to our lived experience.
It talks about a hidden language. What's the album getting at there? What does that mean?
It refers to the idea that many of our routine interactions, signing contracts for everything from phone service to apartments, using credit cards, receiving bills, even just getting official mail, are actually governed by the principles of commercial law embedded in the UCC.
Okay.
But the source suggests most people aren't consciously aware of these underlying rules or how they shape our obligations and rights within those interactions. It's like a language being spoken around us that we don't fully grasp.
And it introduces some interesting concepts, these pairings, like the dynamic between debtor and secured party, and also the distinction between public obligations and private rights. Can you elaborate on how the album presents these ideas?
Certainly. The album emphasizes that in many commercial interactions, particularly those involving credit or debt of any kind, we inherently take on one of these fundamental roles, either the debtor, who owes a payment or an obligation,
Right.
or the secured party, who is owed that obligation and often has some form of security interest collateral to ensure repayment.
Debtor or secured party, a core duality.
Exactly. It also highlights the difference it sees between obligations we might owe to the state or government, like taxes or fines, which it terms public obligations, and the rights and obligations that arise from agreements we make between private individuals or entities in the private sector, governed by contract and commercial law.
This source also uses this really striking metaphor of commerce as an ecosystem of energetic transfer. That's a very different way to think about buying and selling.
It is quite different, yeah.
Yeah.
The album reframes commerce not just as the simple exchange of goods and services for money, but as a continuous flow. A flow of value, obligations, promises, which it conceptualizes as energy, flowing between recognized participants.
Recognized participants within the system.
Right, all operating within the framework, the rules set by the UCC. It underscores this constant duality where we're either, in its terms, giving or receiving value, either owing or being owed within this commercial ecosystem.
And it goes even further, suggesting that our very life force, our ability to work, create, can be seen as a form of collateral or currency in this system. That's quite an abstract idea.
It is definitely a more philosophical, even metaphysical perspective.
Mm.
The idea, as presented in the album, is that our capacity to labor, to create value through our time and effort, is the fundamental basis for many commercial obligations we undertake.
Like, the promise to repay a loan is backed by future work.
Essentially, yes.
Mm.
It manifests as something we might pledge, like our future earnings in a loan agreement, or something that flows as we exchange our time and effort for compensation and employment. It's looking at the human energy behind the financial numbers.
One point from the album that really resonated and seems quite practical was the idea of silence as acquiescence. That seems to have potentially significant implications in commercial dealings.
It does. The album really stresses this point, that in a commercial context, failing to respond to a proposal, an offer, a claim, or a demand, that silence can often be interpreted legally as acceptance or agreement.
So not objecting means you agree.
In many commercial situations, yes, that can be the presumption. This is a really crucial point that, as we'll see, is actually reflected in some underlying legal principles and potentially some UCC provisions themselves, depending on interpretation.
And it describes a signature as a living instrument, a tangible representation of a promise, not just scribbling your name.
Yes, it emphasizes that our signature is far more than just a perfunctory act, more than just identification. It embodies, in this view, a binding promise, a tangible expression of our intention to fulfill an obligation or adhere to the terms of an agreement.
Like putting your energy behind the words.
In a sense, yeah. It's framed as a personal commitment made within the commercial arena, a transfer of, well, the album might say sovereignty or energy into the agreement.
The concept of a corporate doppelganger also stood out from the album notes. What's that referring to? Sounds a bit spooky.
Haha. Yeah, the phrasing is evocative. It refers to the very common practice within legal and financial systems of representing our name in all capital letters on official documents. Think driver's licenses, bank statements, court documents.
The ALLCAPS name, right?
The album suggests that this capitalized name represents a separate legal entity, a kind of persona or straw man that operates within the commercial system, distinct from our living, breathing selves, the natural person.
And why does that distinction matter, according to the album?
The album argues that this distinction, while often overlooked, can have significant implications regarding liability and obligations. It suggests the capitalized name is the entity that incurs debts and obligations within the commercial system, and understanding that distinction is key to navigating it properly.
Okay. And despite all these intricate rules and these sort of hidden dimensions, the album says commerce operates with the impartiality of natural law, focused on contractual personhood. What does that mean? That sounds contradictory.
It seems contradictory, yeah. But the idea presented is that the commercial system, in its ideal form, shouldn't inherently favor one individual or entity over another based on who they are. Instead, it's supposed to operate based purely on the agreements and obligations created by the contractual personhood, that legal entity, often represented by the capitalized name, that enters into commercial transactions.
So the focus is on the terms of the deal, not the people.
Right. The focus is supposed to be on the terms of the agreement, the performance, the adherence to the rules, not the personal attributes or status of the individuals involved. Like a force of nature, it just follows its own laws. That's the perspective.
It also breaks down commercial interactions into this basic pattern of proposition and response, and talks about dishonor as a failure to respond appropriately to a demand.
Exactly. The album views commerce as this continuous exchange of offers, acceptances, demands, payments, propositions, and responses. A demand for payment, a legal notice, a bill, these can all be seen as propositions within this framework.
And dishonor is?
Failing to respond to such a proposition in a timely, appropriate, and what the album calls honorable manner is considered dishonor within this commercial framework. It disrupts the expected flow.
And it even touches on how actions in a courtroom, like pleading guilty or not guilty, or maybe even protesting loudly without a clear legal basis, can be interpreted within this commercial context. How does that work?
The album uses these as examples of how our actions, even in settings that don't seem obviously commercial like a courtroom, can still have unintended commercial consequences according to its interpretation. Pleading guilty or not guilty, it argues, accepts the court's jurisdiction and the premise of the charge within that system. Protesting without specific legal grounding might be seen as dishonoring the process. Our responses and how we present ourselves are always being interpreted within the established rules of whatever system we're in.
Interesting. Finally, the album speaks of an alchemical transformation, strong word, again, that comes with understanding these structures. It allows for conscious engagement, articulating response with honor, and presenting settlement. That sounds empowering, I guess.
That seems to be the core message, yes.
Yeah.
Empowerment through knowledge. The album's underlying thesis is that by gaining an understanding of the UCC's principles and these dynamics of the commercial world it describes, we can move from a state of sort of unconscious default participation,
Just reacting.
right, to one of deliberate conscious engagement. The idea is this allows us to navigate the system more effectively, protect our rights, and honorably resolve obligations according to the rules of commerce as it presents them.
This perspective from UCC Law for the Living is definitely eye-opening. It offers a very different way to think about our place in the commercial world, beyond just the statutes. Now let's try to circle back to the official UCC itself and look at some specific provisions that seem to connect with some of these ideas, starting with UCC 1308, reserving rights. This sounds like it ties directly into that idea of maintaining your sovereignty or position.
It absolutely does. The album, as we discussed, describes our existence within a system with pre-existing rules, where many everyday actions can be interpreted as forming a contract or agreement. UCC 1308 provides a mechanism, a stated way, to participate in the system, to perform or assent to performance, without automatically relinquishing all of your rights or unknowingly entering into agreements you haven't fully considered or consented to.
So you can comply under protest, essentially.
That's one way to think about it. The section itself says that a party who performs or promises performance or assents to performance in a manner demanded or offered by the other party does not thereby prejudice the rights reserved if they explicitly reserve them. It's a way to say, okay, I am engaging in this transaction, I'm doing this thing you asked, but I am not waiving any underlying rights or remedies I may have related to it.
So it's like a legal flag you can plant, saying, I'm participating, but I'm not necessarily agreeing to every single assumption being made here.
Precisely. The album presents it as a kind of universal disclaimer or reservation that allows an individual to interact in the commercial system without theoretically forfeiting their fundamental rights or being railroaded into acceptance. The standard declaration you might see, often associated with this concept, is something like without prejudice UCC 1308 or all rights reserved UCC 1308 written near a signature.
And where might someone practically use such a declaration, according to this perspective? What difference is it supposed to make?
Well, UCC Law for the Living and similar viewpoints suggest using it on various documents, signing contracts, responding to bills or demands for payment, even on correspondence with official bodies. The idea is that it explicitly states your participation doesn't imply unconditional agreement or a waiver of any legal or common law rights.
So if you get a bill you dispute, for instance.
For example, yeah. Including this phrase when you respond, or perhaps even when making a payment under protest might be argued from this perspective, to indicate that you are engaging with the issuer, but not necessarily accepting the full validity of the debt as presented, preserving your right to dispute it later. Of course, we have to stress, this isn't legal advice, and the actual legal effectiveness of simply writing this phrase can be highly debated and depend heavily on the specific jurisdiction and context.
Right, big caveat there. The album even refers to UCC 1308 as a metaphysical firewall. That's pretty strong imagery.
It is. It really emphasizes the idea within that framework that by explicitly reserving your rights under this UCC provision, you are attempting to create a legal boundary, a boundary that pushes back against the presumption of implied consent or waiver or unconditional agreement that might otherwise arise simply through your involvement or signature.
A conscious act.
Yes, a conscious act of asserting your position rather than passively accepting the default assumptions of a commercial exchange.
That makes sense, especially given the album's emphasis on the power of silence implying agreement. So by actively invoking UCC 1308, you're trying to disrupt that potential chain of implication.
Exactly. The album argues that the commercial system often relies on our unspoken acceptance of its terms, our acquiescence. By consciously reserving your rights, you are, in theory, actively engaging and asserting your position within that framework, preventing certain presumptions from taking hold.
Okay. Let's move on then to negotiable instruments and UCC 3104. The album makes this really bold statement that your signature is living currency. Now, how does that connect, if at all, with the official UCC definition of a negotiable instrument?
Well, let's look at the UCC definition first. UCC 3104 defines a negotiable instrument primarily as an unconditional promise or order to pay a fixed amount of money. There are other requirements too, like being payable on demand or at a definite time, and payable to bearer or to order. Checks and promissory notes are the classic examples.
Right, the unconditional promise to pay.
Exactly. Now, the album's perspective takes that concept and gives it that energetic spin.
Yeah.
It argues that when you sign a document like a loan agreement, a mortgage note, even a utility contract, you're essentially creating that promise to pay. You're manifesting an obligation backed by your future labor, your assets, your ability to generate value.
So the signature creates the instrument.
In a very real sense, yes. Your signature on a promissory note brings it into existence as a legally enforceable promise. The album interprets this act as embodying a potential for future value transfer, your capacity to earn and pay, hence the evocative idea of it being living currency. It's your potential energy made manifest on paper.
It also talks about a great inversion, where we effectively create value with our signature. The bank gets credit for it, but then we're asked to pay again with money. Can you unpack that idea a bit? It sounds a bit conspiratorial, maybe.
It can sound that way, and it's definitely an interpretation from a specific viewpoint.
Yeah.
The album highlights that in many credit-based transactions, like taking out a loan, your signed promissory note is the valuable asset that the lender initially receives. This note, this promise, can then potentially be bundled, sold, or leveraged within the financial system. The inversion concept, as presented, refers to the feeling or argument that you, the borrower, have already provided something of significant value. Your legally binding commitment to repay, which has immediate value to the lender. Yet you are then also required to fulfill the monetary obligation over time, often with interest. From this perspective, it can feel like a double extraction of value from your end.
Your promise creates an asset for them, and then you pay them back, too.
That's the gist of the argument presented in the album, yeah.
And it mentions this sort of procedure, this alchemical transformation of endorsing a presentment like a bill or demand with the phrase accepted for value and then returning it. How does that relate to the principles within the UCC? Is that actually in the code?
Okay, this accepted for value concept is prominent in certain alternative interpretations of commercial law, often associated with the sovereign citizen movement or similar groups, and heavily featured in sources like the Avari album. The UCC itself does not explicitly prescribe or endorse this specific phrase or procedure as a standard method for discharging debt in the way these sources suggest.
Ah, okay. So it's an interpretation, not black letter law.
Exactly. The album suggests that by endorsing a demand for payment, a presentment, in this specific way, you are acknowledging the instrument, but also supposedly tapping into some kind of pre-existing value linked to your strawman account or birth certificate registration, using it to settle the obligation.
Right.
While the UCC does have rules about acceptance of drafts, Article 3, and discharge of obligations, Article 3, this specific accepted for value endorsement and the theories behind it are generally not recognized by mainstream legal or financial systems as a valid way to extinguish debt. It's very much outside standard commercial practice and legal understanding.
Good to clarify that distinction. The album also stresses the significance of understanding when to sign in different capacities, like as a representative of an organization versus an individual, or as a secured party versus what the album calls a living sovereign. Is that distinction legally relevant? Signing capacity.
Oh, absolutely. The capacity in which you sign a document has huge legal ramifications, and that's standard legal principle, not just the album's view.
Okay.
If you sign a contract as Jane Doe, President XYZ Corp., you are generally binding the corporation, not yourself personally. If you just sign Jane Doe on a personal loan, you're creating personal liability. That's black and white.
Right.
The album's emphasis on the living sovereign relates back to its idea of distinguishing between your natural self and the capitalized legal name entity. It advises signing in a way that supposedly clarifies you are acting as the living individual and not a surety or accommodation party for the fictional entity, often using qualifiers like by or specific signature styles they advocate. Again, the legal effectiveness of these specific stylized signatures is highly questionable in conventional courts, but the underlying principle of signing in the correct capacity is critically important in law.
Gotcha. So the core idea of signing capacity is real, even if the specific sovereign methods are fringe. This leads us naturally to tender and return, covered by UCC 3603 and 3604. The album calls these the hidden exit. What's the core concept here, according to the UCC itself, and then maybe how the album interprets it?
Okay, let's look at the UCC first. UCC 3603 deals with tender of payment. Essentially, it says that if a party who owes money on an instrument makes a proper offer, a tender of the full amount due to the person entitled to enforce it, and that tender is refused without a legally valid reason.
If they refuse your payment.
Right. If they refuse your proper full payment, then the obligation to pay any further interest after the date of tender is discharged. And if the refusal causes other consequences, the refusing party might be liable for those. It's about the effect of offering payment.
Okay, so refusing payment stops the interest clock, potentially. What about 3604?
UCC 3604 is titled Discharge by Cancellation or Renunciation. This section says that the person entitled to enforce an instrument can discharge the obligation of a party by intentionally canceling the instrument, like tearing it up or marking it paid, or by renouncing their rights in assigned writing, or by surrendering the instrument itself to the party who is supposed to pay.
Ah, so if the lender gives you back the original promissory note?
Yes. Surrendering the original instrument back to the obligor is generally considered strong evidence of intent to discharge the debt represented by that specific instrument.
Okay, so those are the actual UCC provisions. How does the album interpret these as a hidden exit?
The album and similar perspectives often seize on these provisions, particularly the tender part 3603 and the surrender part 3604, and interpret them much more broadly. They frame tender not just as offering money, but potentially offering alternative forms of settlement, perhaps linked back to that accepted for value concept.
Right.
They argue that if any form of lawful tender, as they define it, which might not be actual currency, is offered and refused, the entire underlying obligation is completely dissolved, not just the interest. And they place huge emphasis on getting the original instrument back, viewing its return, especially if endorsed in a certain way, as definitively shattering all liability.
So taking the basic UCC principle and amplifying its effect significantly.
Exactly. The album uses very strong language, like rejected lawful tender dissolves obligation and returned instrument shatters liability.
Yeah.
While the UCC provisions do have real effects regarding discharge, the interpretations in the album often present these effects as more absolute, automatic, and applicable to a wider range of tender than mainstream legal interpretation would support. The specific procedures they advocate for achieving this exit are, again, generally outside standard practice.
Okay, that nuance is important. Finally, let's delve into dishonor, fault, and default, which the album frames, quite provocatively, as winning in silence. That sounds counterintuitive, especially in a legal or commercial setting where you usually need to speak up.
It does seem paradoxical, doesn't it? But the album's perspective here isn't about you being silent. It's about leveraging the other party's silence or failure to respond appropriately.
Okay. How does that work?
The framework presented is this. In the commercial realm, a timely and proper response to a demand, a claim, or a presentment is crucial for maintaining honor. Failing to respond adequately, maybe ignoring deadlines, not addressing specific points, or just not responding at all, can be interpreted within this framework as a form of dishonor on that party's part.
So if they don't respond properly.
Exactly. Conversely, the theory goes, if you make an honorable and lawful response, maybe you make a proper tender of payment, or you make a conditional acceptance outlining valid concerns or disputing the claim with evidence, and the other party then fails to adequately respond to your points or rebut your position.
They go silent.
Right. If they meet your response with silence or an inadequate reply, they may then be considered in dishonor. And if that dishonor isn't cured within a certain time frame, it can potentially lead to their default on the matter, according to this interpretation.
So winning in silence isn't about you staying quiet, but about carefully documenting the other party's silence or failure to adequately respond to your good faith actions or challenges.
Precisely. That's the core idea presented. The album emphasizes the importance of making a clear, timely, and honorable response to any commercial proposition or demand. And then, crucially, meticulously documenting the other party's subsequent actions, or, importantly, their lack of action.
Documenting their silence.
Yes. If they fail to address your substantive response, rebut your position, or meet your conditions within a reasonable specified time frame, their silence can be interpreted, under this theory, as a tacit agreement, an inability to contest your claims, or an abandonment of their position. This, the album argues, can lead to a default in your favor within that specific commercial administrative process.
It mentions specific documents, like sending a notice of fault and then maybe a certificate of default. What role do these play in this interpretation? Are these UCC forms?
These are generally not official UCC forms. In the context of the album's teachings and similar processes, these are documents created by the individual using the process. They are presented as formal steps in documenting the other party's alleged dishonor and subsequent default.
So what's their supposed function?
The notice of fault is typically a formal communication sent after the other party has allegedly failed to respond adequately, pointing out their specific failures, the faults, and usually giving them a final opportunity to cure their dishonor, often within a short time frame.
An ultimatum, kind of.
In a way, yes. If they still fail to respond adequately after the notice of fault period expires, the person might then issue a certificate of default or similar document. This is intended to be a formal declaration based on the documented silence or inaction that the other party is in default, effectively conceding the points raised or abandoning their claim. It's meant to create a private administrative record.
And the album circles back to the idea of silence as acceptance, referencing UCC 1202 and 1213. How do these specific provisions supposedly tie into this concept of default through silence?
Okay, let's look at those. UCC 1202 deals with prima facie evidence by third-party documents. It essentially says certain documents issued by third parties, like weighmasters, inspectors, are considered prima facie evidence of their own authenticity, and the VAC stated, potentially shifting the burden of proof. How this directly supports default by silence isn't immediately obvious in the text itself, though proponents might argue their own notices gain weight if unrefuted.
Okay. What about 12013?
UCC 1201 contains general definitions. Subsection B3 defines an agreement very broadly as the bargain of the parties, in fact, as found in their language or inferred from other circumstances, including course of performance, course of dealing, or usage of trade.
Inferred from other circumstances.
Exactly. Proponents of the default by silence theory often seize on that phrase, arguing that silence is an other circumstance from which agreement or acquiescence can be inferred, especially in a commercial context where there's arguably a duty to speak up or object. So the idea is that the other party's documented silence, following prompt notice according to their principles, can be argued as constituting an implied agreement or a failure to challenge your position, ultimately leading to their claim default within that specific administrative framework they're trying to establish.
It's a very specific interpretation and application of those general principles.
It is indeed. It relies heavily on procedural steps, notice requirements, and interpreting silence in a very particular way, often within a self-created administrative process, rather than necessarily reflecting how a conventional court might view the same situation without that specific documented process being followed.
This has been a truly in-depth exploration of the UCC. We've gone from its historical development and its structural framework, the articles, the updates, to these really thought-provoking and, yeah, at times quite unconventional perspectives offered by sources like UCC Law for the Living. It's clear that this body of law, while often operating behind the scenes, really does have a profound impact on our commercial lives.
Absolutely. It's easy to overlook, but the UCC forms the very foundation, the bedrock of so much of our modern economy. Understanding its core principles, particularly around how agreements are formed, how obligations are created, how performance is expected, and especially how responses, or even the lack of response, are interpreted within commercial dealings, that understanding can really transform how you perceive everyday transactions.
Right. It's not just abstract law.
Not at all.
Yeah.
And as we've seen through the lens of that Avari Solutions album, even something as seemingly passive as silence can be argued to carry significant weight within this system, whether you agree with their specific interpretations or not. The underlying principle of communication and response is key.
That brings us nicely to our final thought for you, our listener. Building on that idea, consider this. How many agreements or assumptions might you have inadvertently entered into, or positions you might have conceded, simply by not responding, by remaining silent when presented with a claim or a proposition? And flipping that, what new possibilities, what different outcomes might emerge from consciously engaging with the commercial world armed with a more informed understanding of these often hidden rules and dynamics?
Yeah, that's a powerful question to ponder. The UCC is, as we've seen, a vast and intricate area of law. We've really only scratched the surface today, focusing on some key concepts and throwing in some interesting, maybe challenging interpretations.
Often that.
We really encourage you to explore the official resources we've mentioned, the Uniform Law Commission website, the Legal Information Institute's Cornell site. They have the actual text and commentary. And just continue your own exploration into this fascinating field that, like it or not, underpins so much of our modern existence. What other aspects of commercial law are you now curious about after this dive?